Judge McBurney, can you hear me? I can hear you, and the court reporter can, so we're good. It's just we're trying to get this properly. Can you hear anything, Ms. Crawford?
Yes, I hear you now. Yes, I can hear you.
Okay, we can't hear you now, but I guess it's because it's almost 5 o'clock. All right, back to you, Mr. Shepard. So your client gets a call from sister and cousin saying this 58-year-old lady has a knife, and the two of us are scared. She's going to overpower us. So bring your gun.
I don't know if they said bring your gun, but they definitely say gun and I'm stabbed. And nobody wants to be stabbed. And obviously, the caregiver doesn't get to say, "Oh, hold on a minute, let me talk to him." None of that's true. What's really happening is so we understand what the state's version of the events are, but what I'm trying to get for purposes of mitigation and sentencing is what information does my client have in his head, and he's not omniscient. He doesn't know everything that's going on, but all he knows is was being fed to him by his mother and fed to him by his sister and his co-defendant. And so he has nothing to do with any of this, but he gets this call and he has the background story that there are allegations that his caregiver has embezzled money. There are allegations that his caregiver beat his uncle, put him in the hospital, eventually kills him, and has stolen money and is living in the house illegally. And all they're trying to do is get her out of the house, but she won't leave. All she had to do was leave. And none of this would have happened. All she has to do is leave, go live somewhere else. You have no legal right to be there. And then
just so I'm getting all the mitigation though, it's not the case that your client or one of his relatives were particularly in need of themselves occupying the house. They just wanted Ms. Benton out. I mean, it sounds like they were prepared to board it up. It's their house, that's not my point, but it wasn't, you gave the analogy of old maid needs to get out so we made them come in. There weren't family members who were saying, "Gosh, I can't even live in my own house because this lady is taking it over."
that is correct. I apologize for the slight discrepancy.
Okay.
She has no legal right to be there. Just want her out. My client has nothing to do with it. It's his uncle, but it's the cousin who is the daughter who wants the house and wants her out. And part of the reason they want her out is because there are allegations of embezzlement and there are allegations that she beat the man and put him in ICU. Something put him in ICU. And the caretaker's version is I think he fell down the stairs on his own. The classic, the housewife who there, "Oh yeah, I hit my eye on the door." So there really isn't a good explanation as to why he ended up in the ICU, and the allegations of the family that are being communicated that she beat him and pushed him down the flight of stairs. So I'm trying to get to the point is that if we evaluate his conduct based upon the information that he had, that he doesn't know the other half of the story, that the call, the frantic call, the caregivers in the house, they didn't know she was going to be there. They just decided she's in the house asleep. That she's trying to stab me, and he's not on his medication, and he snaps. And so we're just trying to fashion a sentence that we think is appropriate. And we certainly think that something in the single digits is more appropriate given the lack of a medication, the fact that he snapped, that he's admitting what he did. He's very remorseful for what happened. He's as depressed as can be. I've been in the back, and I can tell you absolutely he's depressed. More than that is that his actions were based on the information that was being fed to him. And it was being fed to him by people who had an agenda. Two of the co-defendants had an agenda, the mom had an agenda. And based upon this agenda, they basically, launched him like a missile. And the missile did what the launchers intended the missile to do. My client snapped and basically reacted to this information he was getting that he believed to be true. I tried to believe things my mom and my brother and my cousin tell me, especially when there's objective corroborating evidence. And as a trial judge, we know that the fact that the man is in the hospital kind of corroborates that the caregiver who's the only one in the house with him is the one who put him there. The missing money, there is money missing, and kind of in both of these cases I've done it, everybody always looks at the caregiver. This whole frantic phone call from the sister that came over to the house and she's in here, and now she's trying to stab me. Set him up, and very regretful for what he did. we think something more appropriate versus a 12 would be something along the lines of like a 15 or more maybe on the aggravated assault, and maybe a 10 or 4 on the gun, and then 5 consecutive suspended for a 20 to 4. I'm sorry that I was so long-winded at this hour of the day.
No. It's important to get context. We need to sort out the ranges. So it is 1 to 20 for the aggravated assault. It's +5 for the 16-11-106. But the third count that your client is charged with is not the standard possession of a firearm by a convicted felon. That's the hang up. It's 133 and 133. Yeah, it doesn't mean we can't sort it all out, but 133. Yes, not a 133 is a 15-year sentence that runs consecutive. So I know there have been debates. It says punished by confinement. It doesn't say whether it can be probated or whatnot. That may be the conversation you and Ms. Fallman would have about how to structure that. But I'm assuming the 133 was charged because of the crime that it invokes is the aggravated battery from Cherokee County. And if that was a crime that involved the use or possession of a firearm, that appropriately triggers, unintended, 133. I don't know anything about the 97 offense. And maybe Ms. Crawford has more of the charges. We just have all said aggravated battery. But aggravated battery on its face doesn't require a gun, so it's not clear to me that it triggers 133. Okay.
So we would just ask instead of 5 consecutive suspended, 15 and 30 served 4.
Okay.
The first 11 after the 4 being active probation, and the second 15 being suspended. And the mother is here available to basically confirm that that's the information she was feeding to my client, whether that information was accurate or not. I'm here arguing the impact of that information versus the impact, true or not. But I just still do not believe that the 97-year-old took upon himself a 58-year-old girl, that she was the caregiver.
Ms. Crawford, can you hear us or not? Well, she turned her video on, but I don't understand why she can't try to turn. Let me unmute. Ms. Crawford, can you hear me?
Hey, Judge. Yes, I can hear you. Can you hear me?
Let me turn my speaker back on. There's going to be weird reverb, but you don't need to take this down right now. Can you hear me, Ms. Crawford?
Yes,
Yes.
I can hear you.
Okay. What can you tell us about Mr. Miller's criminal history?
So Mr. Miller has an old case from 1995. There was a first offender case, and then there's an old 1997 case out of Cherokee County. Nothing active. So those are only 2 things. Well, 1 thing.
Are you able to see what the charges were from the 97 case?
Yes, he had robbery and burglary before July of 2012.
That's the 97 case.
Yes, I can give you the case number. It's 97CR0176 out of Cherokee County.
Okay, yeah, I've got the case number. I'm just trying to figure out, the indictment says that that's an aggravated battery case. You're saying, and I trust your recitation, that it's robbery and burglary, but there's no evidence that it involved a gun. Okay, thank you.
You're welcome.
We amend to change it to 131.
Well, I'm just gonna say that there's not enough proof to accept a plea on that, so the state can do what they want with it, but there has to be evidence that the 97 case involved possessing a firearm. That's what gets you into the 133 territory. First, it says aggravated battery, which doesn't sound like the right offense, but I think we could agree to amend it to robbery, but if it's not a gun robbery, then we're not in the right territory. And some of this is academic. What drives Mr. Miller's sentence is the aggravated assault, shooting Ms. Benton 6 times in the leg. What was, I must not have written it down. I've heard Mr. Shepherd say it a couple times. The state's recommendation is
aggravated assault.
okay.
And then it was armed robbery in terms of the one church.
Okay.
Reduced from armed robbery to part of the armed robbery, aggravated assault, aggravated battery.
That's all we needed to hear was the firearms piece. Okay. And so aggravated battery was a charge, and that's what's in the indictment. So 133 state. What the whole case was? But it was in there. That's okay. Okay. All right. Mr. Miller, are there any things you want to tell me? I know you're anxious to say a lot. I want to caution you. Mr. Shepherd has covered a whole lot of what we need to cover here, but it's your plea. And so if there's something you think I ought to know, I'm here to listen. So it sounds like what they did was reduce it. What Ms. Crawford told me is that ultimately your conviction was for robbery and burglary. So the okay, keep going. Okay. What else were you going to tell me?
It was being poured on everybody for it, paid judgment on everybody for it. It was like the communication on everybody. Even this business side and my side. I'm super sorry. Everything is disrespectful in your county. I'm very sorry.
I don't think it matters what county it was in. Where was Ms. Benton when you shot her? Was she in the house or out of the house?
Outside fighting.
You say they, meaning you
And
and your cousin.
my cousin Maria and both other guys. Yes, there were other people involved.
Okay.
The next door neighbor, I'm gonna quote you. His little friend, he was outside and was trying to jump my sister and my cousin. I didn't try to defend myself. That's it. I wasn't trying to hurt nobody in the This big grabbed the knife and trying to stab my sister in the neck. He tried to stab my sister in the neck when the guy was holding her. I said, I went trying to shoot nobody. I shot at the leg. I think he still there for 3 times. I ain't shoot no 6 times. I ain't shoot nobody no 6 times. I'm telling the truth. I'm telling the truth. I didn't try to stop the whole situation before it got started. I tried to call the police. I tried to do everything I could.
Did you call the police?
I dropped my phone. I left my phone. I dropped my phone when she tried to stab my sister. Tried to stab my sister back in the neck with a knife.
Did you call the police?
I got scared. I'm not gonna lie, I got scared. I panicked. First thing I said, I'm a big fella with a firearm. Nigga was trying to give me the rest of my life in jail.
Yeah, what were you doing with the gun?
I had got shot 3 years ago in my own driveway. That kind of, before he got shot in his driveway, that's why I brought it on. Cause somebody shot me in my driveway. Brought me in my driveway and shot.
That's the person who shot. Okay. All right, anything else you want to add?
That's what this is, man. I don't Miss Benton forgive me, no. And she, when triggered everything go, she admitted that she killed my uncle. She admitted. She said, no, I killed the old man. She ain't said that word, but she admitted that she killed him. And it triggered them off to keep fighting. I tried my best to stop them. I tried.
Okay. All right. Did you, I guess Ms. Benton was watching on YouTube. She wasn't dialed in such that she wanted to add anything. Okay, all right. I put us back on YouTube so she didn't put it back in. All right. Mr. Miller, do you still feel like you are understanding what's going on? I know you told me that the medication you get for the most part helps you stay focused, but you are missing one of the medications that helps balance everything out. Do you feel like you're following what's going on? Okay, do you want to take a break? Well, I'm not trying to rush you. Do you want, or are you good? You okay if we keep going, Mr. Miller? All right. So, Mr. Miller, I do find there's a factual basis for your plea. I also find that your plea was knowing and voluntary. Knowing means that you've understood the things that we've been talking about. And if you didn't, you and Mr. Shepherd talked about it. Do you have any questions about anything we've talked about so far? Voluntary means that you are entering this plea because it's how you want to move forward. You may not be real excited about the situation you're in, but that's not the test. It's whether someone's forced you into this plea or tricked you into it or promised you something other than Mr. Shepherd's told you what he would recommend and you knew what the state was going to recommend. Do you feel like this is a voluntary situation for you? Okay. So, Mr. Miller, I'm sentencing you pursuant to the Probation Options Management Act. What that means is that as part of your sentence that you're on probation, you don't have to come see me if there's a little problem on probation. But if there's a big problem, you get arrested again, anything like this, then you'll come back to work with me and a lawyer representing you, prosecutor, to figure out what we ought to do with your probation. It sounds like the 28th of March of last year was a pretty bad day for Ms. Benton, obviously, but for your family as well. That you were coming to try to help some people and maybe break something up. But you made a mistake that sadly too many people do in our society, which is they bring a gun to a messy situation. And it's too easy to end up pulling the trigger. And then who knows what will happen. You're real lucky Ms. Benton didn't die. If she died, you'd be looking not at 4 years or 8 years or 12 years. You'd be looking at the rest of your life in prison. And the fact that you shot her could have killed her. She could have bled out. You may have been aiming low and it hits the pavement, it goes up, or it hits an artery in her leg and she bleeds out. She's an older woman, who knows? It's an infection. So you may not feel real blessed right now, but the fact that you can talk about a possible sentence in numbers, rather than the word life, is a pretty remarkable situation. Whether you shot 3 times or 6 times, when you shot more than 0 times. I'm sorry for your family's loss that your uncle passed away. I don't know what Ms. Benton had to do with it. I don't need to decide that right now. Your family may have theories about all sorts of evils that Ms. Benton visited upon your uncle. None of that justified you pulling out a gun and pulling the trigger. You've added a little bit that helps me better understand the situation. That when you arrived, it wasn't that Ms. Benton was standing with her hands up, saying, "I'm so sorry," and she dropped the knife, but that there was a full-fledged melee going on. People were swinging and this and that, and you were concerned for the safety of your cousin, and we're trying to help them out. Still not okay that you shot someone, but it's a slightly different situation, and you rode up and the fight had ended, and you thought it was time for you to have your own sense of justice. Mr. Miller, I think, given your history, that there was, you say you were young, but you were still an adult, a previous situation that sounded pretty messy. And then this, where you didn't just brandish the gun, but fired it multiple times, that a reasonable sentence is that you serve 15 years to serve 7 in custody with the balance on probation. That would be your sentence. As to for you, it's count 3, and the count numbers don't matter so much. But that's 8 years on probation and 7 years in custody. Credit for all the time. It's a parole eligible offense. So you'd be, I don't know when you'd be eligible for parole. I don't control that. Mr. Shepard doesn't control that. Your sentence as to count 4 and 5. 4 would be 5 years consecutive suspended, consecutive to count 3, and 5 would be 15 years consecutive to count 3, also suspended. So those wouldn't be years that you spend in custody. They would not be years that you spend on probation. The sentence that controls when you're in custody and when you're on probation is the shooting one. And as I said, it's 15 years to serve 7 to balance on probation. That's based on the little bit that I learned today. Mr. Shepard was an effective advocate for you. You were an effective advocate for you by helping me feel what was going on at that instant when you showed up and what you saw and what you were reacting to. None of that changes you pulling the trigger 3 times or 6. None of it makes Ms. Benton whole again. None of this clears either of the other 2 defendants. They're going to need to deal with whatever they did, whatever happened to them. It is a little bit more than what Mr. Shepard asked for on your behalf. It's less than what Ms. Hall asked for. I think her recommendation is perfectly reasonable given Ms. Benton's age. And I suspect that Ms. Hall hadn't heard all the things that I got to hear today. So she had part of the story, but not all of it, based on what she had seen and heard and read. Her recommendation is on. The sentence that I am prepared to impose today is more than what Mr. Shepard asked for on your behalf. And it may be more than you're comfortable accepting right now. Today, you have the ability to say, oh, thank you, Judge. I'm not prepared to accept that at this point. I'd rather have a motion and later on have a trial and see how the chips fall after a jury sees the evidence and hears the evidence. 100% that right. The jury will not hear ever that at one point you admitted and tried to take a plea. That's not what they hear. But you're also free to accept this sentence as a final resolution of these serious charges. What I'm going to do is give you a chance to talk with Mr. Shepard. If you have questions for me, you can ask me questions, but I want you to speak privately with Mr. Shepard so he can share with you his insights as to whether going to trial is the right next step or accepting this is the right next step. He's handled many cases, some much more serious, where people didn't survive. And so I think he can give you a healthy perspective on it. But ultimately, it's your decision because you'll be the one who is serving the sentence, not Mr. Shepard. Do you have any questions before you and Mr. Shepard spend a few minutes talking about this? Okay, Mr. Shepard, if you don't mind going back into lockup with Mr. Miller so you guys can speak freely, I will stay right here and work on some of these. Any warrants? Mr. Crawford, are you going to need to chat with Mr. Miller if he accepts the plea, or if you're not going to need to, you're free to go. You've been on with us all day.
I would just need to get an address for him, and I wouldn't give him reporting instructions, just need to get an address.
Okay, we'll get that address.
Okay.
Question is what?
I didn't get this thing. I got a little confused there because I looked at my calendar and said, where's he getting 3, 4, and 5 from? And I looked carefully.
I think it's 3, 4, 5. It is.
It is.
So 4 is 5 consecutive to 3, and 5 is 15 consecutive to 3. Both are suspended. Both are consecutive.
Okay, because I noticed on the Miller case, I think it was the 2 defendants before we scheduled earlier today. You didn't include, you said the 5 is suspended, but you didn't include that in the overall sentence. So it ended up being like 13, ended up being 18 years. I didn't know if you noticed that. So you might want to go over that.
I'll go with him. But what was the other case?
The 2 defendants that were.
Right. The Cannon.
Right. I didn't notice if you noticed that because I was like, he didn't count the 15, you gave the guy 13, and then you gave 5 to suspend. And I was like, that's really 18. But I put it on the sentencing sheet, but I just wanted to point that out to you because you didn't include it. Usually you kind of say that.
Yes. So I either forgot on this book.
Because so what's a little confusing to me is when you say suspended, are you saying that that's 5 years to serve, or that's 5 years to serve on probation and consecutive percent? I'm thinking you're saying to serve.
Yeah, it's 5 to serve.
Okay.
Yeah.
Okay, that's
Yeah.
why I wrote it.
Anything suspended is X to serve. Suspended.
Okay, that's what I thought, but I just thought we talk about it. It's just like.
Your Honor, we're ready.
Okay. I know you're talking to,
I just want to, I'm ready to continue.
okay. No, I'm good.
I'm still in love.
You just need to get this rivers back. No, that's good. I appreciate you taking it. Okay. So we're back on the record in Mr. Miller's case, 20 SC 177191. Mr. Miller took a break to talk with Mr. Shepherd about whether he wanted to go forward with a sentence of 15 to serve 7 with the balance on probation, followed by 15 years suspended, or required by law. But those would be probated years or anything like that. Mr. Miller, did you have enough time to speak with Mr. Shepherd about what you want to do? And do you want to go forward with this plea, or do you want to withdraw your plea? Okay. So, Mr. Miller, your sentence will be as I described. I'm going to add 2 special conditions to your probation. One is, unsurprisingly, no contact with Ms. Batten. So when you're out and on probation, you need to stay away from her. She needs to stay away from you. But you can't reach out to her, whether it's to say I'm sorry or keep away from my family. The other special condition is that you take all medications that are prescribed by medical professionals. So if the doctor prescribes something that will help you with anxiety or depression, you need to make sure you're taking those medications. That'll help you avoid some of the snapping incidents that Mr. Shepherd described, and I think help you keep more of an even keel as you go forward. Okay. We do need to get an address that you expect to be at when you get out for probation. I'm not going to give you reporting instructions got that, or did I get that from you wrong? Okay. What's a good address that we could share with probation, Dan? Okay, and what is that? 1805 Glenhaven? Glenhaven. Got it? I got that, yeah. 30035, okay? We'll make sure that gets to the probation officer, okay? Sounds like a good plan for Mr. Miller. All right, Mr. Shepherd, anything else on behalf of Mr. Miller? Ms. Hall? All right, thank you, everyone. Thank you, Ms. Rivers. It is now after 5, so we're done with presiding. I'm gonna go through the warrants. If you're here with warrants, stick around. I'll just stay out here as it goes. But otherwise, we're done.
Was worth staying.
Thank you for staying. I appreciate it. Tomorrow is third court. Should be a little less needed.
Okay, so number 5 was 15 years old.
Hold on 1 second. We have a pre-trial conference, but you don't need to take that. So other than needing you for our termination, or anything on the calendar that where someone might say, please. Great.
Okay, no, that's okay. I'm just trying to make sure I have this right. So the count 5 was the 15 years to serve as well. So really, he got a total of 35 years.
No, because
Okay.
so it's third. If you do all the math, 15
Yes, I got that.
and then
Right. So my question was, it was a total of 35 years. If you, and you have to count the consecutive.
but I think 4 and 5. I don't think they have.
Okay.
If we're wrong,
Because this is how you said it, and that's why I'm not sure.
Yeah, that's right.
Okay, so then if you have this, that's 15. If you have that, that's 5. Then you have this, that's still 15,
but
even though
it's-
it's suspended. You have to.
Yeah, but it's consecutive to 3, not to 4. If it was consecutive to 4, then you'd be at 20 plus 15. But it's consecutive to number 3, which is at 15. So 15 plus 15 is 30. Thank you for getting them sitting up.
I'm thinking about this to me. It's still saying overall sentence is 35 years, but when you break it down,
But it's not because if count 5 is consecutive to count 4, then
So
it would
this
be
is
35.
consecutive to count 3.
Right. So that if you view it as-
Judge McBurney.
So
Judge McBurney.
So the bottom one is count 3,
Mhm.
and then consecutive to it is the
Ms.
little
Hall.
5. Also consecutive to it is the big one. 4 is the little one. The big one is 5. But they are concurrent with each other.
Okay, see, so that's why I'm missing the word concurrent, needs to go someplace in here for them not to say it's, that's, yes. Okay,
4 is concurrent. 5 is not really concurrent. But 5 and 4 are concurrent with each other. One of the
Okay.
easiest things to say, count 5 is concurrent.
okay,
Because then it should look like this.
you were describing, each one on top of each other, which is, I guess, what happens if you don't use the word.
Yes, okay, thank you.
Sure. Let me see.
Judge McBurney, can you hear me?
I can hear you now. Can you hear me?
Yes, I was trying to tell you that we're still live on YouTube.